Today, the Supreme Court ruled on an issue that could redefine the limits of what a president can do. They tackled the question of whether a former president is immune from criminal prosecution. The decision released by the court today was initially confusing to some of the people gathered outside the court.
So what was your reaction to the decision?
Okay, at first it was confusion. I didn't understand that the Supreme Court was referring to unofficial acts.
That's Celeste McCall. She was outside the court on Monday, and she spoke with our producers.
So I thought, oh, yay. But then it was explained that it's just unofficial acts and not official acts.
Well, I was first trying to figure out what it was because it wasn't clear. But
that's Michael Allen, who was also standing outside the court.
But when you read just a few sentences, it becomes clear that this is not an absolutely clear mandate for anything, that it seems to open.
The reason this case is getting so much attention is because it's directly relevant to former President Donald Trump. This ruling might be the determining factor in whether he faces another criminal trial before the election. So here's what the court ruled in their 6-3 decision. Whether or not a former president can be prosecuted for crimes depends on whether they were acting in an official capacity.
The Supreme Court says that presidents have absolute immunity for official acts, but presidents do not have immunity for unofficial acts. And where you draw that line is obviously critically important, and they don't spell it out exactly.
That is Devlin Barrett. He reports on the Justice Department for The Post. And we wanted to talk with him to get a sense of why this ruling is so consequential.
It matters a lot for two reasons. One, obviously, we have a former president who is facing at least one trial that this ruling could affect. And two, this is really a new and quite broad definition of presidential power, and that may be with us for generations, and that may change how, the government works completely.
From the newsroom of The Washington Post, this is Post Reports. I'm Martine Powers. It's Monday, July 1st. Today, we are breaking down the Supreme Court's historic ruling on presidential immunity, because it is not exactly an open and shut case. We'll talk about what's at stake in this question of immunity and the impact that it could have for future presidents. We'll also discuss another Supreme Court decision that could change the game for January 6th rioters. So, Devlin, I want to go back for a minute and just have you give us a little bit of context. Can you remind us, how did we get to this moment, and what were the actions that Donald Trump took that were at the heart of this case that eventually found its way to the Supreme Court?
Right. So the easiest way to explain it is to go back to the November 2020 election that Donald Trump lost, and then look at all of his actions after that loss to try to undo that loss. And that includes things like assembling Justice Department officials to try to get them to say that there were problems in the vote count that needed to be investigated, talking to state officials and trying to get them to say that there were problems in their individual states with the vote count, and those needed to be looked at, trying to get Republican Party officials in those key states to put forward new slates of electors and submit them to Congress as if they would be the actual representatives of the result. And then, of course, there's all the statements he made leading up to the riot, January 6th, 2021, at the Capitol. Those are the basic categories of behavior, of conduct that prosecutors looked at and ultimately decided to charge Donald Trump. This is Special Counsel Jack Smith decided to charge Donald Trump with 4 crimes, basically all of them versions of conspiring to obstruct the results of the 2020 election.
And of course, we're still waiting for that trial to happen. And the reason that we've been waiting is because we've been waiting to see how the Supreme Court would rule on this. Can you talk me through what are the arguments that Trump's lawyers have made that basically this prosecution of Trump should not, in fact, take place and that it is a violation of the law?
Right. So after this indictment was filed, Trump's lawyers appealed, making the argument that this indictment should be dismissed on the grounds that everything the president does when he's president is covered by immunity of some kind. Not literally everything, but nearly everything, I should say. And the Justice Department argued that's not true, that there's a whole raft of conduct that the Constitution envisions that a president could be charged with once he leaves office. Both sides agree that a sitting president cannot be charged with a crime. The real fight here was whether once the president leaves office, can he be charged with crimes that he allegedly committed while he was in office? That's really the crux of this whole argument. And that's why this case has been on hold while we wait to hear what the Supreme Court says about it.
Interesting. Well, let's dive into some of the details of that ruling. So you said that basically they concluded that a former president is immune for acts that they did that were essentially official acts,
right,
and that they are not immune for acts that are unofficial acts. So what does that mean? Like, what is an official act? What is an unofficial act?
So the court leaves some of that to be decided, but they definitely say that Trump's meetings with Justice Department officials are definitely official acts. One of the things he's accused of doing is pressing his Justice Department to basically take his side in the ballot fighting and the vote count fighting. The Supreme Court said those conversations are absolutely protected by presidential immunity, that that evidence cannot be used against him. He cannot be charged with a crime based on that evidence because it is a core constitutional responsibility of being the president to talk to the Justice Department to give them instruction.
That you're basically the boss of the Justice Department.
Correct.
So this is theoretically an official act.
Right. And they're saying it cannot be a crime. Where they're much less certain are, for example, Trump's conversations with his vice president, Mike Pence, because if you remember back then, part of what was going on in late 2020 was that Trump was pressuring Pence to not certify the Joe Biden victory and instead, accept other slates of electors, other lists of electors, and essentially make Trump the winner of the presidency via the Congress.
But it seems like now the question is, when Trump had that communication with Pence,
right,
was that an official act from a president to a vice president, or?
And the Supreme Court has now said that the trial judge should decide that. I completely expect that whatever the trial judge decides on that score, Trump's lawyers will appeal it probably to the Supreme Court. The other area that's the Supreme Court left vague because they say they don't know enough of the facts are Trump's public statements leading up to January 6th. So, for example, Trump tweeted out, to his followers back in December, be there on January 6th, will be wild. He encouraged people to come to the city, and then he gave a speech, and he talked about, let's go up to Congress. And there's been a lot of debate over what he meant by that. So what the Supreme Court seems to be signaling is we think the public statements are probably covered by presidential immunity, but we are not saying for sure, and we'll let the trial judge make a decision. And then if we have to, it's not really explicitly said, but it's very implicitly said that we may review the decisions that the trial judge makes about where the line is. So
there's a world where this still ends up back at the Supreme Court again before this case can actually go forward, if it does go forward.
I am pretty sure that whatever the trial judge, Tanya Chutkan, rules, that decision will be appealed by Trump's lawyers, and I'm pretty certain they will try to take that to the Supreme Court.
Can you give a sense of how justices, and especially the justices in the majority, were talking about this in oral arguments?
So I think in the oral arguments, you saw a real bright dividing line between conservatives who wanted to talk about the need for presidential power, the need for a president to act without having to worry about, legal repercussions later, and the need for, not just to decide this case, but to decide presidential power going forward. I believe it was Justice Gorsuch who said—
Yeah, but you also appreciate that we're writing a rule for the ages.
Yes.
We're making a rule for the ages, which, I think first and foremost in their minds, in the conservative justices' minds, they were thinking as much about the next 5 presidents as this particular president. That's at least how they talked about it at the oral arguments.
Presidents have to make a lot of tough decisions about enforcing the law, and they have to make decisions about questions that are unsettled. And
this is Justice Samuel Alito during oral arguments.
Available? Do you really did I understand you to say, well, if he makes a mistake, he makes a mistake. He's subject to the criminal laws just like anybody else? You don't think he's in a peculiarly precarious position?
He's in a special position.
And then what did we hear from the dissenting justices? So that was three justices, Justice Sotomayor, Justice Kagan, Justice Brown-Jackson.
Mm-hmm.
And what did they say about why they felt like this, official acts are immune, unofficial acts are unimmune, that they didn't think that was the right way to rule?
So I think the most striking thing to me about the dissent is Sotomayor writing, it's standard in Supreme Court decisions for the dissenters to end their dissents with the words, therefore I dissent. What Sotomayor wrote was, with fear for our democracy, I dissent.
Oh, wow.
So what they are essentially arguing is this gives broad, wide new power, not just to Donald Trump, but to any future president, to do all manner of things that could be viewed as a crime under the law and will now be untouchable. And that they argue that the dissenters argue that what the court has really done is put the president above the law. And that is a very ominous decision for the future of the country.
You seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled.
And this, for the record, is Justice Ketanji Brown-Jackson.
If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes, I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
I don't think there's any allegation.
So you indicated that you expect that this ruling might eventually make its way even back to the Supreme Court, that this is not going to be a quick conclusion to this federal case against Donald Trump. What are the other ways in which this further complicates the process going forward?
So one way it immediately complicates the process, and I think the special counsel's team is going to have to really parse this through and their own evidence through, is what the Supreme Court is saying is that some of this evidence cannot be used against Donald Trump.
Because some of that evidence refers to, quote unquote, official acts.
Right.
So it sounds like the prosecutors are going to have to go through all their evidence and basically separate out, here are things that are clearly official acts, here are things that we could argue were unofficial acts that we could still prosecute Trump for.
Right. And I think the challenge for prosecutors is some of that evidence, even if you can't charge a crime based on, for example, his conversations with the Justice Department, you might in theory want to introduce that evidence as showing Donald Trump's state of mind, his intent, what he actually wanted from this push of his. It seems pretty clear that the Supreme Court is saying you cannot do that. You cannot use this as evidence, even if you are using it only as evidence to buttress based on his unofficial acts. I think that's a pretty significant blow for the special counsel's case here. But, people are going to have to parse this out. People are going to have to – it's not something you're going to be able to figure out, in an afternoon. It's going to take a while, I think, for a lot of lawyers to digest this, argue about it in court, and then, maybe go back to the Supreme Court.
And just to remind people of the timing here, this was a case that was originally scheduled to start back in March of this year, obviously has been on hold until then. The question lingering over all of this is Trump going to be in court?
Right.
Well, really for this at all, but specifically, is he going to be in court before the November election?
Right.
Does this ruling from the Supreme Court basically guarantee that Trump will not see the courtroom for this case before November?
I mean, I hesitate to use the word guarantee only because predicting the future is hard and I don't like to do it. But I will say it's very hard now to see a scenario in which this case goes to trial before the election. But we'll have to see, because now this whole case goes back to Judge Chutkan, and she, I think, has shown that she wants to move quickly. The question really is, with this set of instructions, how quickly can she move? I don't think she can move that quickly ultimately, because there's so many factual and legal issues that now have to be argued over, hashed out. but it wouldn't surprise me if she tried.
What do you think this ruling means for future presidents and the power that we give to the executive branch overall?
I think they have a lot more power as a result of this decision. I remember in the very early days of the Trump administration, a senior government official telling me that, part of the challenge that Trump presents as a commander-in-chief is that he tests a lot of limits and he's going to take things to court and he's probably going to lose a lot of things in court. And, Trump won't necessarily care because he's just interested in like whatever battle he's fighting on a particular front. But over time, what you're going to see, this official said, is I think you're going to see a reduced presidency, a weakened presidency, a smaller presidency, because what benefits Trump in the short term may not benefit the presidency in the long term. I think about that conversation a lot because what you see today
is the opposite. Yeah.
What you see is that Trump's fighting these pitched legal battles have led to a decision that defines presidential power, I think, very broadly. I think even the people who agree with the decision would say this is a broad definition of presidential power. I think where the conservatives and the liberals disagree is conservatives would say the president's power has always been broad, and the liberals would say, no, you just made it broad. The president has never had this amount of power and this amount of, sort of immunity from prosecution, and you just gave that to him or her.
And what are the concerns there? Like what would that mean for the future? What could that look like? What are situations where this ruling could come up in ways that, empower future presidents?
So, for example, the way this conversation existed pre-Trump was about things like drone strikes. Does the president have the authority? This is one of the really, tough questions that lawyers in the government wrestled with for years, was does the president have authority to, for example, kill a suspected terrorist who happens to be an American citizen in Pakistan? To use like one micro example.
Or could he be prosecuted for murder after he finishes his presidency?
Exactly. And essentially, without ever directly answering that question, the legal system has largely said the president's not going to be prosecuted for that. I think what this decision raises a really interesting question of, so what are the limits of what a president can order the government to do that in some other context would be illegal, would be a crime, but would not be a crime in this context? The scenario that was suggested as this issue was argued out through the courts was, could the president just order SEAL Team 6 to go assassinate a political rival? And I don't really love that analogy because it sort of assumes the entire military chain of command is willing to just murder people for no reason or for a bad reason.
Yeah, it's probably a little bit more complicated than
right.
that.
But I do think there is an interesting question now raised by this decision is like, so where is that line? If simply by the act of a president, him or her ordering a subordinate to do something, does that something immediately become, always legal? Are we back to what President Nixon once said, which is that if the president does it, it's not a crime? Because that was essentially the Nixon argument. And the courts in real time more or less rejected that. And he didn't test that principle. What's happened here, I think you could say, is that Trump decided to test the principle and the courts gave him some of what he wanted.
After the break, I talk with Devlin about why the Supreme Court threw out an important criminal charge for dozens of January 6th rioters. We'll be right back. So, Devlin, I do want to switch gears and talk about another related Supreme Court decision that came down this past Friday. And this was regarding the January 6th rioters themselves who stormed the Capitol. In that case, some of those rioters were charged and convicted of obstructing an official proceeding. That was the charge. But the Supreme Court ruled that prosecutors can't actually charge rioters with that. So can you tell me a little bit about that case and why it matters?
So Joseph Fisher was one of the people charged with storming the Capitol. It wasn't the only charge he faced, but it's one of them, and hundreds of other people have had this charge included in their January 6 charges. Fisher challenged the charge saying, I didn't obstruct anything. There has to be some tangible thing that I obstructed, a document, a witness, something. You can't obstruct a building, essentially, was his argument.
But isn't it obstructing like the certification of the...
Right. That is the prosecution theory of why they charge this, is that it's obstruction. And prosecutors like that, using that count in part because it sort of captured the essence, the most important idea of why January 6th was bad, right? They weren't storming the building because they were mad at the building or that they were mad at lawmakers. They stormed the building because they wanted to prevent the certification of the winner of the election. And that's quite bad, obviously, for a functional democracy. And so from the prosecutor's point of view, this was a very good charge and a righteous charge. It also had the added benefit from their point of view. That charge happens to carry a 20-year maximum sentence.
Oh, interesting.
So it was a big
basically
stick.
Makes it much more
Correct.
Makes it a more serious set of charges with
Correct.
a potential
and
potentially more serious punishment.
Correct. And they can induce more guilty pleas that way. What the conservative justices said in saying you can't do that is you're too far removed from an actual thing that's being obstructed. You can't, they basically found that if you want to obstruct it with a document, if you want to obstruct some kind of, actual physical process, that's obstruction, but not this general concept of an event.
So this Friday ruling sounds like it was good for Joseph Fisher and his trial, but does it also affect some of the other January 6th cases?
Up to a point, because it's often charged in addition with a bunch of other crimes. Most of the people, even if they have this count dropped against them, most of the people facing this count will still face other charges. There's a small band of people for whom this is a very important decision, and that band of people are basically those who were charged with only misdemeanors and this felony. It is also potentially consequential to the Trump case in some way because that's one of the counts he was charged with. I think most legal experts think that count on its own should survive against Trump because of what's called the false elector scheme, which did involve paperwork. But I think both of these decisions, the one sort of like overlapping commonality of both these decisions is that you're seeing, I think, in real time, the special counsel's work get whittled away here by the Supreme Court.
And that also makes me think about the state of the Supreme Court right now, right? Like this is an institution that has become polarized, that a lot of Americans don't really believe in anymore or don't believe them to be objective or unbiased in the way that we were sort of taught in grade school to view them. And that trust has hit record lows in recent years, especially because, we have seen some reporting of late of justices who themselves or their family members have expressed opinions about January 6th or have demonstrated, being on one side or another. What impact do you think these decisions could have on the public's view of the court?
So I think, one, it's really important to remember that the current makeup of the Supreme Court is 6 conservatives and 3 liberals. And that informs so much of what happens there. I think a lot of the public doesn't quite understand how significant that large majority is going to be for years. I also think the more that Congress is dysfunctional, and I think Congress is incredibly dysfunctional, the more the White House is unable to move Congress on issues, and I think mostly because of Congress's dysfunction, every president is having a harder time moving Congress on anything. More critical issues get pushed to the courts to essentially be the final and in some ways only arbiter of some of these issues. And that's a bad structure. That's a bad, it's sort of a very bad habit of our federal government. And I think it will further erode people's faith and confidence in the Supreme Court. It makes the court more political than it already is. And it's not that the court was never political. I think the challenge is that the court is becoming more political every year because more political issues have to be settled there because they're not being settled in the political space. And so you're making the legal system settle more and more political issues. And the more you do that, the more people are going to distrust and suspect the motives of the legal system.
Devlin, thank you so much for unpacking all this. Really appreciate it.
Thanks for having me.
Devlin Barrett reports on national security and law enforcement for The Post. Before we go, there is one major story that I've been paying close attention to. What happens now with President Biden's campaign? In the days since last week's shaky debate performance, Biden has been on the campaign trail, making the case to voters that just because he had a bad night doesn't mean that he's not the right person for the job of president. This was him at a rally in North Carolina on Friday.
I don't walk as easy as I used to. I don't speak as smoothly as I used to. I don't debate as well as I used to. But I know what I do know. I know how to tell the truth. I know right from wrong. And I know how to do this job. I know how to get things done. And I know, like millions of Americans know, when you get knocked down, you get back up.
And behind the scenes, the Biden team is attempting to shut down any signs of revolt in the party, according to reporting from our colleagues. The campaign has been working overtime to reassure nervous donors and concerned lawmakers. Meanwhile, Biden's family is encouraging the president to stay in the race. The Post has also reported extensively about Biden's debate prep, how the president sequestered himself at Camp David with more than a dozen aides to get ready for the debate, how the president had practiced answers to every topic moderators asked about. Aides told the Post that they were bewildered by the president's performance, and many felt that they had never seen him collapse so dramatically. That reporting is from Tyler Pager, a White House reporter for The Post. And tomorrow, I'll be sitting down with Tyler and our colleague Aaron Blake for a closer look at what's happening inside the Biden campaign during this complicated moment. That will be on tomorrow's episode of The Campaign Moment, and you'll also be able to hear that here in your Post Reports feed. That's it for today's show. Thanks for listening. If you want to show your support for Post Reports, please subscribe to The Washington Post. Not only is it a great way to help us continue to do this work, but you can now get access to Washington Post podcasts ad-free in Apple Podcasts. Subscribe in Apple Podcasts or by following the link in our show notes. Today's show was produced by Peter Bresnan with help from Laura Benshoff. Production support from Trinity Webster Bass and Ali Bianco at the Supreme Court. The show was mixed by Sean Carter and edited by Rena Flores with help from Lucy Perkins. Thank you to Debbie Wilgorin. I'm Martine Powers. We'll be back tomorrow with more stories from The Washington Post.